Afternoon. I'm Jim Leonick. I'm an attorney and I handle estate matters among other things, but today I'm going to speak a little bit about estate matters and finances. Some of the frequently asked questions that I get from clients and from beneficiaries in estates relates to the money because, of course, when it comes to estates, everybody wants to know how much they're getting and where the money is going. So one of the first things that we have to deal with is once an executor is appointed or an administrator, they want to know what happens with estate debts. So for instance, credit card bills, car loans, and things like this. And there's a lot of misinformation that floats around. People think that because someone passed, you can avoid paying these debts. That's not so. You personally and the beneficiaries are not personally responsible for debts, but you do have to pay estate debts if there are estate assets to pay them with. Some other things that people ask about have to do with access to funds. So if there's a bank account, can they access those funds? Well, if you have a joint bank account with the person who passed, many times you can. You certainly shouldn't be using their credit cards or anything like that, but if you have access to funds initially, you can access those funds if they were jointly held. If they're not, then you have to wait until you've been appointed as the representative on behalf of the estate. Once you have access to funds, then you can start paying bills. You can pay utility bills, credit card bills, and other things. Usually you want to negotiate some of the bills down. Credit card bills can often be negotiated down based upon the amount that's in the estate or how much funds you have access to. One of the last things that you'll work on as an executor or estate representative has to do with paying the beneficiaries. As well as paying the executor if the executor is taking an executor's commission, which they're entitled to. Prior to releasing any funds to the beneficiaries, we suggest that you have them sign what's known as a receipt, release, and waiver. This releases the estate as well as the executor from liability. So we can give an informal accounting to the beneficiaries, let them know how much was in the estate, how much the debts were, what is left, and then everyone can see that they're receiving their fair share. And typically what we do is we send them a copy of the check made out to them along with the receipt. We ask them to review it, sign it, and send it back. And then once they send back the original, we send them the original check. The last step in the estate finances is to file an inventory with the court. That shows what was received in terms of different types of assets, whether there was real property, whether there was cash accounts, annuities, life insurance, and things like that. And that becomes a permanent record with the court so that if anybody wanted to go to the court, look at the public record, they could see where the funds from that estate came from. So these are just some of the issues that come up on a regular basis. If you have other questions, I have 30 years of experience handling estate matters, and I'd be happy to help you with any of them. Thanks.